Again, you're required to list all your publications. You're also required to list the compensation that you're being paid. So you want to make sure you do this in your lab three, well, your lab three reports you submit today, so it might be too late for that. But anyway, when you do your reports, you need to list the compensation you're being paid. Now, when you list your compensation that you're being paid, you need to make sure that's either an hourly rate or a flat fee. You do not want to have compensation that is based off of a commission. And what I mean by that is if the side that you're working for wins the case, you get much more money than you would get if the side you're working for loses the case. That would show that you had a financial bias in the case, would indicate that you're not objective, then you'd most likely be disqualified as an expert witness. Also, you have to list all the cases in which you've testified as an expert witness during the past 4 years. If you have not testified in any cases during the last 4 years, then obviously you don't have anything to list. You're not required to have prior experience here. Okay. But if you do have it, you must list it. Once again, the reason for this is to make sure that you're not saying something today that contradicts something you said in another case. If you are contradicting something you've said before, again, that might not be a problem if the technology has changed, if the answers have changed, but it could be a problem if you're just trying to change your answers so that the side that hired you wins the case. Okay. Why do you think let me ask the class a question. Why do you think it is that you don't have to have any experience? You don't have to have any prior uh, testimony to be qualified as an expert witness. I mean, what I'm saying is you can be qualified as an expert witness, brought in to testify on the witness stand if you have no experience. Why do you think you could be qualified as an expert? Why do you think the courts allow that if you have no experience?
Because that's not the sole determiner. There's the four other elements.
That's right. There's five elements, but yes, you're correct that it's a combination of the entirety, which is your education, your training, your certifications, your experience, or other special skill. So you're right about that. But why do you think it is that the courts say you don't need experience to be considered to be an expert? Anybody want to zero right in on that one issue? Why do you not need experience to be considered an expert? Anybody care to guess at what that might be?
Just to
Why?
verify, sir, is it we don't have to have experience testifying or we don't have to have experience in forensic?
You don't have to have experience working any prior cases. Uh, you don't have to have any experience as being a forensic examiner to be qualified as an expert computer forensic examiner. And anybody want to care to guess why that might be?
It wouldn't have to do with your academic credentials, would it?
Not necessarily. I mean, academic credentials are one of the things we look at in the Daubert criteria. It's your education, your your training, your certifications, experience, or other special skill. It's that in its entirety. But why is it? Do you think the courts don't really require experience? Anybody?
Could it be just because the field changes so fast that past experience might not mean much?
Well, I hear you. I'm not going to say that's not a reason. There's something else. There's one other thing that I think is even more uh, to the point on this. Very, I think all of you will immediately see it once we discuss it. Anybody want to care to guess? Any other guesses before I let the cat out of the bag here and tell you what it is?
Is it so that there's lots of available experts? Because if you only had a few, then they might be tied up in other cases or in other places. But if you have lots of people available to or qualified to be an expert, then you'll have lots of different options for your cases.
You're not wrong. That is hinting at the idea that I'm trying to get at here. But the reason for it is because if we required experience, we'd never have anybody new enter the field. You have to allow people who've never worked a prior case to get new people into the field. I mean, everybody has to work their first case. Every forensic examiner out there had to have their first case. So if we required experience, nobody would be able to come up and do this because nobody would, you can't do your first case if you have to have experience to do it.
Professor, wouldn't the other attorney use that against you, though, saying that you have no experience, therefore we shouldn't validate your expertise?
Well, experience can count. I mean, training can count in lieu of experience. I mean, the Dahlberg criteria, again, it's the combination of these 5 elements, your education, your training, your certifications, your experience, or other special skill. So maybe you don't have any experience, but you've got education. You've been and you guys, for example, if you can somehow pass this course, then I'm certain you'd be qualified as an expert witness because you would have completed a 16-week-long graduate course in digital forensics where you learn not only the digital forensics process, but you had hands-on activities including data acquisition, data analysis, and reporting, including simulated court testimony. And in this 16-week-long course, you use the court-validated tools of EnCase and FTK. And then you can discuss in more details about the type of analysis you did or data acquisition you did, all that. Anyway, that separates you from the herd right there. Most people are not trained in computer technology, for one thing, but then not only are you trained in computer technology, but you've had a specific course, a 16-week-long graduate course in digital forensics. And so your education would certainly put you up there to help you, so you can be qualified to be an expert witness. But you don't just stop there. You might go off and do more things. And if you enter the field profession, you certainly would. You'd take training courses. You might do self-paced training as well. And then you would earn different certifications. For example, I have an ENCE, which is an EnCase Certified Examiner certificate. Then you would earn experience as you go. Okay. So, but anyway, get on with that. These are things that are required in your CV or your resume. You have to list your qualifications, including all publications, your compensation being paid, and cases that you've testified within the last 4 years. Okay.
Professor, only once we get the YNCE can we call ourselves investigators, correct?
Don't ever call yourself an investigator.
Never.
Unless you have a private investigator license.
Okay, so the YNCE is something completely separate then.
No. ENCE is an EnCase Certified Examiner. Okay. And now, if you notice a lot of the terminology that guidance software uses when they talk about doing forensic examinations, they'll put that word investigation in there a lot. And there's a reason they do that. And that's because that company, Guidance Software, they have a lot of consultants that they hire out who are forensic examiners who go all over the country working computer forensics cases. But EnCase, the Guidance Software, the EnCase people, they have a private investigator's license at the company level. And they'll use that term investigation frequently because they can and you can't. Don't ever call yourself an investigator unless you have a private investigator's license. They almost do it as a trick or a trap, okay? But you're not an investigator. You're not an investigator. You're a forensic examiner. An investigator is somebody like a detective. There will be likely be an investigator somewhere in the case, but that's not you. You're a scientist, a forensic examiner. You're not investigating anybody. You're analyzing computer data.
Okay, thank you.
You're welcome. So you have to write your own report, and don't worry about the rule number. I'm not going to put that on exam or quiz, but just be aware it exists. The idea here, this requires an expert to write and sign the expert report, which contains a complete statement of all your opinions to be expressed and reasons for the opinions. My suggestion is when you write the report, leave the opinions out of the thing. Just state the facts. No, you might get called on the witness stand And then they'll ask you if you have an opinion regarding something, and you can answer that question. And then they'll ask if you have an opinion on this. If you do have an opinion, they'll ask, what is it? And let that go into the record that way. I just prefer not to write the opinions in the report. Okay. There might be a specific issue that the attorney that hired you wants you to include in the report. If so, you can include it, but make sure you use your own opinion, not the opinion the attorney wants you to give. You have to be accurate on that. When you write your report, you have to give it to the attorney that hired you, who has to give a copy of it to the opposing attorney prior to the trial. Well in advance of the court date, you'd finish your report. Your attorney would give a copy of your report to the opposing attorney. So that attorney has the opportunity to not only read your report, but hire their own forensic examiner, who can analyze your report and make sure that it's accurate. Scrutinize your report. And I've said before, when you write your report, you write it with the understanding that it will be read by others. It will be scrutinized by others. The other side will read it just like I read it when you submit a lab exercise. I read it looking for fault. I read it looking for errors, and that's what they do. They want to see, did you make any mistakes in that report? Maybe you made errors in your calculations. For example, last login dates. You didn't get the correct time zone analysis there. Maybe you've made some other mistakes in converting the time or whatever. Maybe there's other mistakes that you've missed with evaluating some data. Maybe you've just got grammatical errors or spelling errors or whatever else. But anyway, any of those errors would show carelessness in the report. Okay. Even formatting errors. Again, it shows carelessness. And maybe you were careless when you did your analysis. Okay. So anyway, the other side will examine, they will scrutinize your report. They are entitled to get it in advance so they can be prepared for the trial date to know what questions to ask you regarding your report. That's why I require the reports to be turned in today, so I have time to prepare for in the future when I put you on the witness stand that I'll be able to read your report and pull out questions for it. Okay, some cautions here. Before accepting a case, an expert must ensure there is no conflict of interest. So let's suppose you're a forensic examiner and you're working a case. You currently have one that you're under contract with. And let's suppose that this attorney number one from law firm A is the attorney that hired you. And in this case, you're going up against attorney number one from law firm B. Suppose law firm B is a large law firm, lots of attorneys working in that. And you're working in this case. It's a relatively small case, but nonetheless, you're hired by attorney one in law firm A to work this case. Now, while you're working on this case, another attorney number two from law firm B, approaches you and says, I have a very large case coming up. I'd like to hire you as an expert to work on this case. Can you accept that case? I'm asking the class here. Can you accept that case? Would that be a conflict of interest?
Not right now.
So you said not right now. Is that what you said?
Not right now. Because it'd be a
Okay.
conflict of interest.
So I have one vote for saying no, you can't. It would be a conflict. Do I have other opinions on this? Can you accept that case? Anybody else?
I think it would depend on the case. I mean, if it's on two separate things, I don't see why not.
Okay, I hear you, because any attorney is most likely working multiple cases at any one time. And if one case has nothing to do with another, why would it matter? I hear that point of view. So you're saying perhaps not. Other people, what do you think about this? Would this be a conflict of interest or not? Other people, what do you think? Is this a
Yeah.
conflict? Not a conflict.
I think a forensic examiner is able to work on multiple cases at any given time.
Okay, so you're saying ethical conduct and your responsibilities to the court would say it wouldn't matter. You should be able to work it, and there's no conflict there at all. That's what I'm hearing you say there. So
As
we've
long
got
as long as the cases are not related or there's no relations in between the cases, I think
all right.
it's
I hear
fine.
you. Okay. Anybody else have a different take on it? Any other
Professor,
argument?
just to clarify, you're being hired for a second case by the first case's opposition lawyer?
That's not the lawyer, but the law firm.
Law firm. Okay.
Mhm.
I think because
So,
there's a monetary issue here, you're getting paid by that other firm, there might be a conflict.
okay, I hear you. So a law firm A is paying you for a case, and law firm B, you're against them with the first case, and they're saying they got a really big case coming up. You get paid a lot more money. And can you take that? Okay, so you start to see some of the dilemmas here. Is it could be that it's not a dilemma because attorneys work multiple cases at any given time. Forensic examiners probably do too. However, you're being paid to deliver your work product, and in that comes an opinion, and which goes into the court record. And one side's paying you a lot of money, more money than the other. Could you be swayed by that? So I guess the real answer here, how do you know? How do you know if it's a conflict of interest or not? Well, the short answer is you don't know. So then what should you do? Well, you find out. How do you find out? You start by asking the attorney. Well, first of all, when the second attorney approaches you, attorney number 2 from law firm B says, I have this really big case coming up. I'd like for you to work it. What you would need to do is full disclosure. Say to this attorney, number 2 at law firm B, I'd love to work this case, but please be aware I'm working this other case right now, and your law firm is the opposing firm in this case that I'm working. Do you see that as a conflict? That attorney might say, oh, not at all. In fact, that's how I learned about you. The attorney number 1 from law firm B told me that you were working this case, and we need a forensic examiner on this case I'm working, and he's the one who recommended you. So they might not see that as a conflict at all. Does that mean you have no conflict? No, it doesn't. You still need to go now to the attorney that you're working for, attorney number 1 from law firm A, the one you're working that small case for, and say, I've been approached by attorney number 2 from law firm B asking me, can I work this case? A very big case they have coming up. Would that be a conflict? And the attorney number 1 from law firm A, who you're already working for, might say, yes, I see that as a conflict because that's a very large case, large sum of money that might sway your decisions. Or he might say, oh, not at all. That case has nothing to do with this case. But so the answer is you don't know. As a forensic examiner, you don't know if it's a conflict or not. So the thing is you ask the attorneys, both sides. Now, if both sides say there's no conflict, then there's no conflict. But if either side says they see it as a conflict, you've got a conflict. Don't take it. Okay. So that's how you resolve that. Okay. Make sure the attorneys know, full disclosure. And, okay. You'll find that in the real world, each attorney might be working, multiple cases, 10, 15, 20 cases at any given time. They'll be arguing back and forth in court because they're opposing each other on a certain trial. It'll get lunchtime. The court will recess for lunch, and the 2 attorneys will go out and have lunch together, and they'll talk about their families and vacation plans and hobbies and everything else. And then they'll come back into the courtroom and resume their arguments, arguing back and forth against each other. They're just 2 professionals doing their job. And when they're not in the courtroom, they might be best of friends. Okay. All right. But anyway, it's a profession. So talk to the attorneys to determine if there's a conflict. Next thing is when you disclose your compensation, it says you must avoid unreasonably high compensation. So what is that? Well, forensic examiners get paid very well. So the normal compensation of a forensic examiner is plenty good enough. Okay. That's actually the true reason I got into this field many, many years ago. tell you the details maybe another time, but it certainly was based off when I learned how much money these forensic examiners get paid. And if it's a flat fee or an hourly rate, you're fine, even if it's quite large. But do not have it where it's based on the outcome of the trial. Like I said before, like a commission based. No, don't do that. That would be a real problem. The third bullet, the expert must write the report. You can't have somebody else write the report for you. You got to be the one who writes it, person who did the analysis. Okay, so the bottom bullet, people may attempt to falsify electronic evidence, so lawyers have the right and obligation to question the validity of the evidence. So you think about that. So the evil opposing attorney might seem like a jerk, badgering you with question after question about the procedures you used and the results that you got and how you did things in this report and why you did what you did. And you look at the reason for that. Not only do they have the right to question you about the evidence because it could be falsified, it could be changed, it could be altered, it could be misrepresented, but they're obligated because they're hired to represent their client in court. So not only do they have the right to ask you these questions, they're obligated. So they're just doing their job. And if they seem like a jerk and they seem like they're badgering you, just keep in mind they're just doing their job. You do your job, answer the questions honestly. Okay. We'll get more to that later. Excuse me. Okay, so you see federal judges are more likely now to scrutinize the expert testimony before a trial. Lawyers are more likely filing motions in limine, challenging the admissibility of expert evidence. So they try to do all this in advance. The reason they do this in advance is so they don't present some evidence in a trial that the jury is not supposed to hear. Because once you mention something, they cannot unhear it. So the reason this is all discussed before the trial to determine which evidence is admissible and what is not is to prevent inadmissible evidence from being presented in the trial. Excuse me. Computer forensics is a growing field. Now, I say it's a relatively new and rapidly growing field. It certainly is. Here we say investigation, interpretation, and presentation of electronic evidence are complex and filled with technical terms. I put that word investigation in there just to try to, rub it in everybody's mind and kind of a sore spot. We don't use that term. It's analysis. We're not investigators. Okay. Explaining electronic evidence to non-technical jurors is not an easy task. You're having to explain something very technical and complex that happened in a computer system to people who are not technical. We talked at length with chapter 2 on key technical concepts about how some of these things work. And we've got to look at how we can explain that to non-technical people. In this particular case, the judge decided that expert testimony did not infringe upon the right of a defendant to have a jury decide guilt. And as a result, this has been snowballed. Almost all cases these days have expert witnesses involved. And so, as I've said, most trials, most cases are swayed one way or the other because of the testimony of the expert witness. Okay. The court noted that an expert testimony helped the juror understand the case's drug trafficking issues. That's in that particular case. I gave the example a little bit earlier about a medical situation. Courts widely argue or agree that expert testimony about drug trade or any topic as far as that goes is admissible. Okay. So the courts have embraced the idea of expert testimony. Let's think about the trial process. So there's a few things that happen before the date of the trial, okay, leading up to it. First, you've got the discovery phase. That's where people are going out to find evidence, see what evidence is available, get subpoenas or search warrants, and then analyzing that data. There's various pretrial motions, maybe motions in limine to change the venue from one place to another. No, I mentioned change the venue. You also have the motions in limine to allow or suppress some evidence being presented, to discuss the expert witnesses, determine whether they're qualified. Depositions. Depositions is like courtroom testimony, but it's done outside the courtroom. Maybe you have a witness who cannot come to the trial. Maybe they're in the hospital and they cannot leave. Maybe they're in a prison. Maybe they have a very unusual schedule, very busy schedule, like an executive of a corporation or something, or some politician or something who's in office. And so the two attorneys can go visit these people, whether in the hospital or in prison or in their own office. And then they'd have a court reporter with them. The attorneys would ask questions. The person would answer the questions. The court reporter would record the answers, produce a transcript of the questions and answers. And then that would be presented in the trial, just as if the person was on the witness stand. So after the discovery and pretrial motion, a civil case may be dropped, settled, or proceed to trial. Proceeding to trial is a last resort. Our whole system is designed to let us hope that we reach some kind of settlement before a trial, something that everybody can agree on. We only go to trial is if we can't reach an agreement. Again, that's the last resource there, is the trial. A criminal case can be dropped by the prosecution, or the defendant can accept the plea bargain deal, or the case can proceed to trial, again, as a last resort. Our system is designed to get us to agree on something first instead of court. Okay, now during the trial, the lawyers publicly present their evidence and the legal theories to the judge and the jury. The judge ensures that only the proper evidence and theories are presented to the jury. But now keep in mind, when those attorneys present their theories about what happened, those attorneys are not under oath. They can say things, they do say things that are not true. Sounds strange, but they do. They try to present their case their way, spin the ball the way it is in their favor, and try to present it to sway the jury's thinking. Then later the evidence is presented, and they're going to try to make the evidence look like it's going to affect them. If the jury members, this third bullet, ultimately decide the weight and credibility of the evidence they're allowed to consider. Okay. Remember way back, I gave the example of, say, I was accused of running over a little old lady with a car, and the forensic examiner comes in and says, accelerated position, 100%, braking condition, 0%. Now, the attorneys are going to argue what that means. My attorney is going to argue that, it was an accident. I got my foot on the wrong pedal. I tried to stop as hard as I could. I pressed what I thought was the brake as hard as I possibly could. Unfortunately, in my haste and excitement and confusion, I got my foot on the wrong pedal. The prosecuting attorney is going to say I'm a bad guy, that I deliberately intended to run over the little lady. I pressed the accelerator. I saw her. I pressed the accelerator as hard as I possibly could. I floored it, squashed the little lady, but flat. I'm a bad guy. You see, the attorneys are going to argue what these facts mean. And it's the jury that has to decide which one's more credible, which one they believe. Okay. So those attorneys are not under oath. Okay. The lawyers are obligated to try to impeach witnesses. Impeach a witness means you get them to contradict themselves, or you get them to say something that's not true, and then you can show that, and then that would impeach them, and then they would be set down. They'd be disqualified as a witness, and their testimony would be stricken from the record. So they're obligated to try that. So we think that evil opposing attorney is such a bad person because they're badgering you with questions, trying to trip you up, trying to get you to make a mistake. Well, that's their job. Okay. They're just doing their job. Okay. You be a professional, you do your job and answer the questions honestly and accurately. Okay. The bottom bullet, there will be conflict with respect to what each side claims are the facts. Think about the situation I just mentioned with the gas pedal, brake pedal situation. My attorney's going to say I'm a good guy, tried to stop, got confused, I panicked, got my foot on the wrong pedal and tried to stop as hard as I could. Unfortunately, it was a mistake. Opposing attorney, the prosecutor is going to claim I'm a bad guy. I intentionally pressed that pedal. So you see, there's conflict with what the two sides claim. So an expert witness has an ethical duty to protect the legal system and the Constitution. Okay, you have an ethical duty to the court that cannot be compromised. As a professional, your duty is to the truth, not to the person who hired you. The person that hired you wants you to say something a certain way. If that's not the way the facts are, the way you see it, you do not say it. You testify on the truth. They still have to pay you. Okay, the attorney that hired you must pay you, even if you say something they don't want you to say. Your job is to the truth. You have ethical duty to the court. The third bullet says a voir dire is a preliminary examination of a witness to determine their competence. So that when a new expert witness is introduced to the court, there'll be some question as to whether that person is qualified to be an expert witness. So if you're introduced by one attorney as an expert witness, the opposing attorney might say, I don't know anything about this person. I don't believe they really are an expert. I'd like to voir dire this expert. Well, the attorney that hired you is going to introduce you and they will present your qualifications. Now, as I said before, you're evaluated off your education, your training, your certifications, your experience, or other special skill. If you have some of those areas, they're going to brag about that tremendously. If you're lacking in something, they're not going to mention those areas at all. Okay. For example, if you got wonderful education, they're going to talk about that. If your grades weren't good, they're going to mention the education you have and the courses you've completed, but they're not going to mention your GPA. On the other way, but if you do have a good GPA, you bet they're going to make a big deal of that. They're going to really make a big deal out of all your qualifications, and they're not going to say anything about the areas that you're weak in. You're going to wish your mother could hear them say the things that they say about you because they're really going to paint you up as something really special. The opposing attorney, though, is going to come up and start asking you questions, and they're going to try to make you look like an idiot. They're going to really emphasize things you don't have, and they're going to kind of belittle the things you do have. And then after the attorneys have argued about your competence, then the judge will make a decision as to whether to make you an expert or not in this, to qualify you as an expert. Okay, so that's the voir dire process. Okay. The witness is examined to prevent damaging evidence from a witness who may not be credible. Okay. Jurors are also voir dire. You know, if any of you have been called to jury duty and you're in the big pool of people waiting and they call your name up, you notice that once they call your name up, then the attorneys will then ask you some questions. The judge might ask, do you know anybody involved in this case? Have you been a victim of this kind of crime? Has anybody in your family been victimized by this kind of crime? A few questions like that. They'll ask you probably questions about your education and your background. Who knows what they might ask you. But anyway, they'll ask you a bunch of questions, and then they might release you. Though that process of asking you questions to determine whether you'll remain as a juror or not, that is also called the voir dire process. Now let's think about what happens in the trial, the process that happens. On the day the trial begins, the first thing that happens will be opening statements by the attorneys. Now we're talking about a criminal case here. A civil case is very similar. We just use different words. We have the plaintiff and the defendant, where in a criminal case, you have the prosecution and the defendant. But we're going to use the terminology in a criminal case here. But on the opening statements, the prosecution goes first with opening statements. followed by the defense. Now, the reason for this, think about the whole nature of criminal trial. The person on trial, the defendant, is considered to be innocent unless proven guilty. You don't have to prove your innocence. The prosecution has to prove your guilt. So for that very reason, it's the prosecution who goes first, because they're presenting the whole reason we're there to begin with, because you're innocent unless proven guilty. Excuse me. So the prosecution will get up and, ladies and gentlemen, in the next few days, you're going to see a lot of evidence brought forward. It's going to show that the defendant, caused great harm to our community, in the likes of which we've never seen, committing unspeakable crimes, and then start naming off what these things were: littering, jaywalking, graffiti, defacing public property, using foul language in public, whatever horrible crimes this person committed. And based off all of this evidence that you're going to see presented in the next few days, then you're going to come to the rightful conclusion that this witness shall hang by the neck until dead. And anyway, the prosecution attorney is going to make their opening statements about that. Then after the prosecution attorney makes his opening statements, the defense attorney will come up, make their opening statements, and he'll say things like, ladies and gentlemen, and the jury, thank you very much for your time and consideration and your service. You've got an important role in front of you. You must decide the fate of this defendant. And you will see, as the evidence is presented during the next few days, that even though horrible things happened in our community, had it not been for the heroic actions of the defendant, who's wrongly accused of these actions, the situation would have been much worse, because you'll see that as these things were taking place, it was the defendant, and only the defendant, who came forward and put himself in harm's way to prevent this situation from being worse than it was. And as he was trying to prevent these actions from happening, he was wrongly accused as being the one causing these actions. And after you've seen all the evidence, you will come to the rightful conclusion that he is a hero in our community and should be presented with the key to the city. So you see these two attorneys give their opening statements, and it sounds like two different movies, but that's, and the jurors will no doubt be confused by this, so they'll need to see the evidence. So after the opening statements, the prosecution must bring their witnesses forward. Remember, the defendant's innocent unless proven guilty. So the prosecution has to bring their evidence first to try to prove guilt. So the prosecution will bring their first witness, and then that first witness will present evidence, okay? Now, if that first witness, or the first witness for the prosecution, if that person happens to be an expert witness, then maybe they'll be voir dired. If it's an eyewitness, they're not voir dired, but if it's an expert witness, then they might have to go through the voir dire process. Assume they pass that, the prosecution will then perform the direct examination. In other words, they're going to ask questions to this witness. For example, if it's an expert computer forensic examiner, they'll ask them, do you have an occasion to work a forensics case regarding the Price Software Company? Yes, I did. Did you complete your analysis in that matter? Yes, I did. As a result of completing your analysis, did you produce a report for the court? Yes, I did. Is this a copy of the report you produced for the court? Yes, it is. Is this your signature in this report attesting to the accuracy of the information contained therein? Yes, it is. And then they'll say, in your report, did you show any evidence regarding auto theft? Yes, I did. Can you elaborate on that, please? Yes, we found 3 items of evidence regarding auto theft, and then you start naming what those things were. So that's the idea of how direct examination would be. The attorney that hired the person will then ask them to explain things about what they found with their analysis or what they wrote in the report. Now, after the prosecution has completed their direct examination, asking questions of this witness, the defense gets to come up and cross-examine that witness. And they're going to try to poke holes in the testimony. They're going to ask them questions about how they did their analysis, question the tools or the methods that they used, question the findings, and then see if they, have areas that they're not so certain in, or raise, again, questions. Well, I call raise FUD, fear, uncertainty, and doubt, to the juror about the testimony of this witness. So they're going to try to poke holes in the testimony. Suppose they were successful. They poked some holes in that testimony, raised some questions, put some uncertainty out there. Well, after the defense has completed that cross-examination, the prosecution gets to come back up and redirect this same witness. This time they're trying to patch up any of those holes that might have been raised by the defense attorney, give the witness an opportunity to clarify something that might seem questionable that was said earlier. And then after that prosecution attorney has redirected, then the defense gets to come back up and recross. Again, trying to either tear open those wounds that were patched up or expose new questions or problems. Okay. And that process repeats, the redirect and recross for this witness until there are no more questions for this witness. And when there are no more questions for this witness, then the prosecution will call their second witness. And that entire process repeats. If it's an expert, it may be voir dire. Prosecution does the direct examination, defense does the cross-examination, prosecution redirect, defense recross. It repeats until there are no more questions for this witness. Then the next witness is called, the next, and the next, and the next. And for each one, that process completes until the last witness, the nth witness for the prosecution. And this, when there are no more questions for the last witness for the prosecution, then the prosecution rests. Now, once this happens, the prosecution has presented all of their evidence. They have nothing else they can present. Even if new stuff comes up later on, they can't introduce it. Okay. When the prosecution rests, they've presented all of their evidence. So at this point in the trial, there's some things that can happen. One thing that is very unlikely to happen, it's very rare, the defense could request a directed verdict. So you might wonder, well, what is that? You see, the idea here is the defendant is innocent unless proven guilty. So if the prosecution presents all of their evidence, and that evidence doesn't establish any kind of guilt, then there's no reason to proceed. You don't have to prove your innocence. They have to prove your guilt. And if they don't do it, well, then we can stop right there. And that's what the attorney would request, a directed verdict to the judge, Your Honor. We're here because the prosecution claims they have evidence about my client. They presented all they've got, and they've got nothing. Move to have this thrown out, a directed verdict of not guilty. And so if the judge would grant that, then the trial will be over there. It's very unlikely to happen because the prosecution knows this, and they're not likely to ever bring a case to trial unless they have sufficient evidence where they think that the defendant is guilty. So since that's the case, now we have to have the evidence from the defense brought forward to try to raise reasonable doubt about this evidence. So here the defense will call their first witness. And again, if it's an expert witness, just like before, witness might be voir dire. Now they might not voir dire an expert witness. Maybe it's an expert witness who's testified numerous times in the past. They've been qualified as an expert witness in this subject matter, and they've testified a lot. There's no reason to voir dire them. It's already been established they're an expert. But if it's somebody relatively new, then they're likely to be voir dire. Also, if an attorney wants to brag about the credentials of their expert, then they would want to voir dire them. The opposing side might not want them voir dire because they don't want the jury to hear the credentials of that expert. Yeah. So here, the defense calls their first witness. The defense is the side now that does the direct examination. It's opposite from before because this is a witness for the defense. So after the defense has done the direct examination, it's now the prosecution that comes up and cross-examines this witness. Likewise, the defense can redirect and the prosecution can recross. Just like before, only the roles are reversed now because these are witnesses for the defense. And this will repeat, this redirect and recross until there's no more questions for this witness. When that happens, the second witness for the defense is called, and that same process repeats. Maybe voir dire is an expert. The defense does the direct, prosecution does the cross, defense does redirect, prosecution does recross. repeat till there are no more questions for that witness. And then the next witness is called. Process repeats. The next witness is called. Process repeats. Continues on like that until there are no more questions for the last witness for the defense. When that occurs, then the defense rests. Once the defense rests, we've had all of the evidence from both sides presented in the court. No more evidence can be presented. If somebody forgot to mention something at this point, it's too bad. Okay. So now, after both sides have rested, we go to the steps next. It'll be the closing arguments. So, first thing in the closing arguments, the prosecution attorney will come up and talk to the jury and explain in the court what we just saw. Ladies and gentlemen, in the last few days, you've seen a lot of evidence brought forward that clearly establishes that the defendant committed these horrible crimes in our community, the likes of which we have never seen. It's disrupted our entire peaceful life. This person ran wild in our city, using foul language and placing graffiti on our public property, and jaywalking and running amok in the city and vandalizing property. Horrible, unspeakable things have happened. And after seeing this evidence, you see that it was this defendant who is guilty of these charges, and by law, they should hang by the neck until death. And then, of course, the defense attorney comes up with their closing arguments. Ladies and gentlemen, the jury, thank you so much for your time and attention during the last few days. You have seen all of this evidence brought forward that shows you the terrible things that happened in our community. And you saw the evidence presented that shows that as bad as it was, how much worse it would have been if not for the heroic deeds of this defendant. It was only this defendant who came forward and put himself in harm's way to prevent these terrible things from happening. And as he was there trying to prevent these bad things from happening, he was mistakenly accused of being the one doing these deeds. You saw from the evidence that he is a hero, and he should be recognized as such. And not only do you find him as not guilty of these ridiculous charges, but he should be given a key to our city. Thank you. So you see these two attorneys then do their closing arguments. Again, the jury might be confused because they just like to watch two different TV shows here. But what's really interesting is after the prosecution did their closing arguments and the defense did their closing arguments, the prosecution gets to come back up and do another set of closing arguments. This time, they do it a little bit differently. This time, when the prosecution comes back up to do their second set of closing arguments, they'll say, ladies and gentlemen of the jury, you're tasked with an important role. You have to fill out these forms to show guilt or innocence in this trial. It's very important that you fill these forms out correctly. So on this first charge, this charge of jaywalking within the city, in order to return a guilty verdict of this charge, on this form, you need to check this box. In this column here, check this box. And then on the second charge of graffiti, if you look at this line here on this report, you make sure to return a guilty verdict, you would check this box. It's necessary here. And then they go through showing each of the charges the person's accused for and how to fill out the paperwork to return a guilty verdict. They don't show the paperwork on how to fill out a not guilty verdict. They just explain how you fill out the paperwork to return a guilty verdict. And then after the prosecution has done that second closing argument showing how to fill out the forms, then the judge instructs the jury goes away to their chambers to deliberate. After they've reached the decision, they come back in, the verdict is read in the court. And now the losing side, because one side is going to win, one side is going to lose, the losing side may appeal. If this does go to the appellate court, they don't hear all this evidence again. They look to see, did this process happen as it should? Did each side get to call up their witnesses? Did the witnesses, was an expert, did somebody request a voir dire? Was it granted? Was a witness qualified who shouldn't have been, or the other way around. Was the evidence presented? Was this evidence admissible and shouldn't have been, or was it not admissible and should have been? Did the attorney get the opportunity to do direct examination, or the other attorney get to do cross-examination? Did they have the opportunity for redirect and recross? Were objections made that should have been sustained, or uh, you know, was the wrong call made on any of those decisions? So the whole thing about appellate court is, did the process follow correctly? Not, is the person guilty or innocent? Was the process correct? Okay. Are there any questions about this trial process? Is everybody still with me?
Yes,
Yes,
sir.
sir.
All pretty straightforward.
All right, we've been going for an hour here. We're going to take a little break here in just a minute. Here's a situation where this one person was indicted for obstruction of justice, trying to tamper with the witnesses a little bit, asking them to clean up some files. And because he gave flawed instructions to the judge gave flawed instructions to the jury. Here in this particular case, the jurors asked for a dictionary so they could understand some of the terms. Judge wouldn't allow that because that's basically allowing new evidence to be admitted. Jurors can hear testimony, hear recalls of information from evidence that was presented in the trial, but new information cannot be introduced. And giving them a dictionary for them to do their own research, if you will, is introducing new evidence. Okay. So jurors rely on expert testimony. We've already established that. The jurors come into the trial typically without technical, financial, or specialized knowledge to understand the evidence. Okay. So verbal and nonverbal behaviors are both taken into account when assessing the credibility of others. So when you think about when you're on the witness stand here, giving expert testimony in trial, your nonverbal behavior will speak loudly to the jurors. Are you saying things with confidence? Or do you have doubt in your voice when you explain things? You get the idea. We'll talk more about this when I show about how to give effective court testimony in a few minutes. In fact, let's pause here and then come back with that, and then we'll focus on some steps to do to how to give effective court testimony. It's 8:03 now. Let's come back at 8:15. Give you a little bit longer break, give you a chance to relax a bit. So come back at 8:15. We'll resume there. Okay. Okay, we'll resume back. As the slide indicates here, some cautions about when we're giving expert testimony in a trial. First bullet says weak testimony, weak arguments, weak and strong cases. So if we think about this for a minute, suppose you are very, very good and thorough and accurate when you do your forensic analysis. And you're very conscientious and very thorough and accurate when you write your report. You're very careful, you organize the report carefully, your grammar is perfect, you present the information very clearly in the written report. But then when you come up onto the witness stand and you're asked questions by the attorneys regarding your report and your findings, you stumble there. Weak testimony weakens strong cases. Example, if they ask you, how many examples of auto theft, how many items of evidence regarding auto theft did you find in your analysis? 3? You get the idea. That's, not a good answer. But much better if they said, how many items of evidence did you find regarding auto theft? And you respond back, found 3 items of evidence regarding auto theft. Then they ask you, can you elaborate on each one of those? Yes, and then do so. All right. So now the voir dire process is often used to cast doubt on an expert witness's opinion. So when an expert is first introduced as an expert, the opposing side will often request to have them voir dired so that they can try to raise questions. I call raising FUD, fear, uncertainty, and doubt, in the juror's mind about the credentials of this expert. Now, some guidelines for testifying. Testimony requires clarity, precision, conciseness, and completeness of your findings and facts relating to the case. Now, all through the semester so far, all through the course, I've been trying to emphasize the idea of using the correct terminology, be very precise in what you say. You want to be concise, not just precise. You want to be concise. Don't say more than you need to say. Say what needs to be said and then stop there. Be complete in your findings. Okay. But again, be very objective. Keep in mind, you're paid for your time and your expertise. And you're paid because of your knowledge in computer technology. You're not paid for the opinion that the attorney wants you to give. Okay. That's not a hired thing. Your opinion is naturally derived based off your area of expertise and the findings that you have. Okay. Those with opposing views will fight fiercely to prevent the jury from believing you. So you can bring forward very good evidence in a very sound manner and present that clearly. Now, if that evidence damages the other side, you can bet the other attorney is going to fight fiercely to try to belittle your evidence, try to question you, your methodology, the tools you used, the accuracy of the information you found, anything they can do to try to belittle what you have come up with. That opposing attorney will fight fiercely. Okay. They're going to be extremely annoying to you, but they're doing their job. Okay. That's what their job is. Your job is to present the facts. Okay. Keep in mind, perjury, which means lying in court. See, as an expert witness, you are under oath to tell the truth, the whole truth, and nothing but the truth. If you lie in the court, that's the crime of perjury. Perjury is a criminal offense, punishable by imprisonment or a fine. So you think about this, it's worse than that. If your career means you're working as a computer forensic examiner, that means your pay comes from being a computer forensic examiner. If you perjure yourself in court, in other words, you lie on the witness stand while under oath, that is a crime. You can go to jail for that. Judge can sentence you to jail right then. Okay. Now, if that happens, you're out of a career because nobody is going to want to hire a forensic examiner who's already been found to lie in court, who's been found guilty of lying in court. That person's future as a forensic examiner is non-existent. Nobody wants to hire an expert who's been found guilty for lying in court. Okay. Now, your work product is subject to scrutiny. Your work product is the report that you produce and, of course, the testimony you provide, which means the opposing counsel can review it and attempt to refute your findings. Excuse me. So often, as we said before, the opposing attorney will get a copy of your report before the trial. That's part of the law. They will review it carefully. They're likely to hire their own expert to read through your report, to look for any kind of mistakes at all, so that they can refute it, so that they can argue with you in court about this and try to expose any mistakes that you've made, anything to try to discredit your work. So some guidelines on testifying. First of all, how do you prepare? Well, you prepare by reviewing the documentation that you've made as you work through your case. Look at the methods and tools you used. Go back and refer to your journal. You kept a logbook of everything that you did while you worked this case. Look at the results of your analysis. So all that should be in your logbook. Realize that this case that's about to come to trial, you probably did the analysis a year ago or more. Okay. And that during the time since you worked this case, since you did the analysis, you've probably worked many other cases since then. So you need to go back and refer to your logbook to see exactly what happened. It's extremely important that you keep a logbook of all the activities you perform. Realize that during the time between when you conducted this analysis and you report on this in court, the versions of the software you're using might have changed, likely did change. You might come up with new techniques since then that weren't available, or you stopped using some technique that you did use at that time. You probably have to refresh your memory as to the reasons why you did what you did and what did you find and why. So review all that. Second bullet here, work closely with the attorney to review details of testimony and anticipate questions. The attorney that hired you is going to work with you to make sure you're prepared as an expert witness. They're going to give you some idea of the types of questions that you might be asked, but they're not going to tell you the questions that you're going to be asked, especially the questions that they're even going to ask you. That might sound funny to you. Give me just a second here. You might wonder, why is it that the attorney that hired you, who wants you to do well, why will that attorney not tell you what questions they're going to ask you? And the answer is really quite simple. Because if you know the questions the attorney is going to ask you, well, you're going to prepare how to answer those questions. You're probably going to come up with your lines on how to answer it. You're going to try to memorize that answer. And then you're going to try to recite that answer back when asked. And it's going to come across as very phony because you're not that good of an actor. All right? They'll tell you the types of questions they're going to ask you. You can be prepared. And so, but you would answer the questions then with your own words when asked in the courtroom, because they don't want you to rehearse your answers, because that comes across as so phony. All right. Now, remember the bottom bullet item here. The jury may still reject what it cannot understand or believe. So you explain to the jury how you were able to retrieve this evidence based off data that was in FileSlack, that you retrieved from a file that had been deleted and partially overwritten by a new file. And the jury members might say, I don't believe he can do that. I've deleted stuff on my computer before, and I sure can't get that back. I don't believe he can do that. Okay, keep that in mind. They might reject what they don't believe. They might reject it because they just don't like you. Okay. During cross-examination, an expert's opinion may be impeached, okay, because of these different reasons. Bias or partiality. If the attorney can show or make the jurors suspect that you are biased or show partiality in this case, then you can be impeached. Okay. For example, if you start writing your report before you complete your analysis, then it'll show your prejudice in this case, because your report's of your findings. And how in the world can you write about your findings if you haven't completed your findings? That would show you had prejudice involved. The interest or amount of pay. If you're being paid in commission, if the side that hired you wins, you get paid a higher financial stake than otherwise. That would show that you have an interest in the outcome of this case. Prior inconsistency. You have written something in the past, or you have testified in the past about something that's opposite of what you're testifying today. Insufficient qualifications. You're trying to give an opinion on something that you're not qualified to do so. And insufficient basis. Again, you're trying to extend an opinion on something that's not your area of expertise. Okay. I did mention to the class, didn't I, about the time I testified in a case where I was made an expert on plagiarism. Didn't I discuss that in this class?
Yes, sir.
Yeah, I thought I did. I won't go into details, but you see what happened. I was asked about plagiarism, and the opposing attorney said he's not an expert on plagiarism. He's a computer expert. So the attorney voir dired me, and then moved that I've been declared an expert on plagiarism. The judge said granted. So then once I had that basis that was my field, then they asked, do I have an opinion whether this is plagiarism? Yes, it is.
Professor, has an attorney ever gotten under your skin?
Well, they all do. They all do. But the thing is, and I'm about to show this in the upcoming slide, maintain your professionalism, keep your cool, answer the questions honestly and accurately, be polite to them, answer your questions, even if you don't like what they're doing. And I'm going to explain why in a minute. Now, this bottom bullet says adequate preparation can eliminate these weaknesses in testimony. So make sure that you're prepared. Okay, now presenting evidence. So here's what we keep in mind is we're on the witness stand now presenting. The other part was how to prepare. So present a professional appearance and demeanor by doing these things. Okay, number one, speaking slowly and clearly. I agree with that. The last part of this, I don't. It says, and avoiding nonverbal communication. I'd clarify that a little bit. I do think speaking slowly and clearly is a real advantage, because you're talking about some technical concepts here that the jury are not going to have in the front of their minds. It's going to be foreign to them. This is going to be complicated, stuff they're not familiar with. So speaking slowly and clearly is going to be very helpful. Now, nonverbal behavior, and I've got this slide show up so you don't see all my nonverbal behavior here, but if you held perfectly still and said, whatever your answer was, present a professional appearance and demeanor by, and you had no nonverbal behavior at all, that would be so annoying, it'd be distracting. And also too much verbal behavior. You're ranting and raving, you're throwing your arms, flailing your arms all around. That would be distracting also. However, a little bit of nonverbal behavior I think is very good. For example, if you said, I found three examples of auto theft. That, and also nodding your head slightly when you're presenting some facts. I found in class, when we do the face-to-face classes, I often do this in an experiment. I'll present some information, and as I'm doing it, I'll make eye contact, looking throughout the class, and I'll nod my head as I'm doing this. And I'll find the majority of students are nodding their head back at me. Okay. It just kind of subtly confirms the validity of whatever it is that I'm saying. So a little bit of nonverbal behavior is good. Just don't overdo it. The next thing there, being truthful, careful, precise, and patient. Absolutely. That's really the crux of what we're doing. You must be truthful. You're under oath. If you're not, you're guilty of perjury. You go to jail, be out of a career. Be very careful. Careful so that you don't commit perjury. Careful so you don't make a mistake. Precise. Use the correct terminology, the correct nomenclature. Explain things precisely as they are. And that last one, the patient, I'm going to come back to that one in a minute. We'll get to that in a few minutes. Next thing, dressing like an expert, whatever that is. So what do you do here? Often, that would be something like a business suit, but not always. If you're working in a profession where you wear a uniform, that might be the appropriate dress. If you're working in an office, it's often going to be a business suit. Now, I have testified in Hawaii. Does anybody know what formal business attire is in Hawaii?
Is it more
Anybody?
relaxed?
So could you say that again, please?
Is it more relaxed, like maybe not a shirt and collar, or
It's a little something different than that. Anybody want to take a stab at what it might be, a formal business dress in Hawaii?
Not a
Well,
Hawaiian.
say that again.
It's
What
not a
was-
Hawaiian shirt, is it?
Yeah, it is. It's an aloha shirt. Okay, a Hawaiian shirt. That's that, long pants and shoes that cover your toes. That's formal business dress in Hawaii. And yes, when I testified in Hawaii, I wore aloha shirts. Okay.
Professor?
What's that?
For the lab four, since we're going to be testifying, do you want us to dress up also?
No, I don't. I'm going to get to that too, but you do not need to. You just need to dress like a college student for my class. Just be legal. That's the only thing. You don't have to dress up for my class. But like I said, in Hawaii, it's formal business attire, Hawaiian aloha shirt. I've certainly done that, worn that. The attorneys wore that. Everybody in the courtroom except for the judge. The judge had a robe on. I have no idea what was under the robe and don't want to know. But everybody else was in aloha shirts and long pants and shoes with shoes that cover your toes. Okay. But anyway, dress like an expert. I think a business suit tends to work best in court. But again, in the classroom, well, you're a college student. Okay. Now, the next thing, not arguing, shouting, avoiding answers, or becoming defensive. The opposing attorney is going to try to get under your skin. Okay. He's going to try to irritate you. He's going to badger you with questions. He's going to try to question your results and make be so annoying because he's going to try to raise questions about every procedure you did. And it's no doubt going to irritate you. But realize that attorney is doing his job. His job is to try to mess you up. His job is to try to impeach you. His job is to try to discredit you. He's doing his job. And the more annoying that attorney gets, it's probably because your work is pretty good and he's not been able to discredit your work so far and he's trying extra hard to mess you up. Don't argue with that attorney. Present your facts calmly and realize if they ask you a closed-end question like a yes or no and your answer might come across as misleading based off the evidence you're trying to show, keep in mind the attorney that hired you gets the chance to come back up and redirect you. Okay. So if he does open up a wound, so to speak, raises a question and something you say with forcing a yes or no answer, then realize the attorney that hired you can come back up, redirect, and let you expand on and clarify that answer. Okay, so don't argue with them. Don't shout back at them. Don't avoid their questions and answer them directly. Even if that answer might seem to be not what you're trying to, not what the evidence is showing, but answer the question accurately and honestly. You keep in mind this, that attorney might be so annoying, really getting under your skin. Realize the jury has been watching this attorney for probably a day or two already. The jury probably has already recognized how annoying this attorney is. The jury members probably don't like that attorney already. If you remain professional and keep your cool, answer the questions to the best of your ability, politely, okay, as a professional. The jury members, first of all, they're going to respect you. They're going to understand you're a computer nerd, and this evil attorney is annoying, is just really bashing you, and you're a computer guy, computer nerd. And here you're keeping your cool and answering the questions nicely, and this attorney's being a jerk. If you keep your cool and answer the questions honestly and accurately, the jury's going to have a lot of respect for you. They'll think highly of you. However, if you argue back with that attorney, shout back at that attorney, try to avoid answers, then the attorney's going to move you right down on the same level as that attorney. They're not going to like you either. Okay. So keep your cool, maintain your professionalism. You'll do good. If you're asked a question and you don't know the answer to, the answer is, I don't know. Okay. That's not a great answer, but it's a much better answer than saying something different. Okay. Tell the truth. Tell the truth. Okay. Now, the bottom bullet says, be relaxed and looking at the jury while answering. Now, this seems really odd. Now, looking at the jury while answering seems foreign. Normally, when we have a conversation with someone makes eye contact with us when they ask us a question. When we answer the question, we make eye contact back with them as we answer the question. But that's not the way it's done in court. We do make eye contact when they ask us the question to make sure we really clearly understand that question. We listen, we hear the whole question. We think before we start talking. We hear the question, we understand the question, we think, and then when we answer, we turn to the jury and we answer the question to the jury. Now that seems really awkward to us. It is. It takes a little practice, but that's the way it's done. Okay. Now, responding appropriately to counsel. Now, counsel, those are attorneys, right? So how do you respond appropriately to an attorney? First, well, as I was just alluding to, you wait for each question and learn to speak for the record. Let them finish their question. Okay. The next bullet, making sure you understand the question before beginning to answer. Those two things work together. Let them finish their question in its entirety before you start talking. Make sure you understand what in the world they are asking before you start talking. After they've completed their question, think for a few seconds before you answer. Let me explain why we do all this. The attorneys are taught how to ask questions in law school. And if they start asking a question and you start talking before they answer, they're going to put a different ending on that question to turn the direction of it, which is going to make you look really foolish. And if you don't understand their question, now you've got some real problems if you start talking. Also, they might ask a question that they shouldn't. Pause and think before you start answering, because that pause gives the attorney that hired you the opportunity to object to that question. But if you already are answering, that objection is going to do no good because your words have already come out. So when the attorney is asking you a question, hear the entire question in its entirety. Let them finish. Make sure you understand it. If you don't understand the question, ask them to repeat the question or ask them to rephrase the question. Okay. Tell them you don't understand the question. Could they please rephrase it or ask it again? Okay. But make sure you understand it. And then pause and think. Give your attorney an opportunity to object. Okay. Answer the question specifically without trying to avoid it. They might ask a question that really seems like it's going to damage what you've been talking about. That's okay. That's all right. Your ethical duty to the court is for the truth. Just answer truthfully. Okay. Avoid answering ambiguous questions. Trying to educate the questioner, trying to argue, bluff, or hide harmful facts. So let's look at this. An ambiguous question is something that could have two meanings, and you're not sure which it is. Okay. So if it's an ambiguous question, avoid answering that. Ask them to clarify that. Say that question's ambiguous. Could you please clarify that? What you mean by that question? Don't try to educate them. Just answer the question. Okay. Don't argue with them. Again, that's going to put you down on the same level as that annoying attorney. Just answer the question. Don't try to hide harmful facts. If they bring up some facts from your analysis that seems like it's going to be damaging to what you're trying to show, it's fine. Just remember, the attorney that hired you is going to get the chance to come back up and redirect you. Okay. Just let the truth come out, whatever it is. And don't ever, 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 ever try to bluff them. The attorneys are taught in their first year of law school never to ask a question in which they don't already know the answer to. You realize they've already read your report. They've already hired their own expert to help them understand your report. They know the answer already. So do not ever try to bluff. If you try to bluff, that's going to come back at you like a tuna milkshake. And I can assure you that's not pleasant. All right. Okay, here's an example of how an interaction might be. Attorney might say, "What is this evidence?" or "What does it purport to be?" Forensic examiner would answer, "This is a printout of data I recovered on June 15th, 2006 from the hard drive primarily used by John Doe of the Big Ace Corporation." It just answers the question completely, but stops there. Don't keep going. Just answer the question. The attorney says, "From where did this evidence allegedly come?" The answer: the hard drive was taken from the office of John Doe on May 15th, 2006. It was contained within a generic PC bearing model XXXX and serial number YYYY. So just answer the question. No more. Okay. Answer the question and shut up. Wait for the next question. Now, as you're presenting evidence, sometimes you're going to have some very painful testimony. It says you may need to testify a full range of crimes from harassment to homicide. No matter the circumstances, you must be prepared to discuss the evidence directly and professionally. So, for example, let's suppose that you're in a trial and it's a murder trial. Well, the victim is not there because the victim is dead. But in the courtroom is the suspect, the person accused of committing the murder. Also in the audience of the courtroom is the parents and family of the victim, the person that was murdered, and the parents and family of the accused, the defendant, and friends of these people. They're all in the courtroom. And now I suppose this was not just a murder trial, but it was a torture and then murder trial. And you got to present some evidence. Now, this is going to be painful evidence, but you just present it directly, honestly, and as professionally as possible. Do not get emotional. Do not shout about it. Do not rant and rave about it. Don't stress certain words as you say them. Just present it. Think about a medical doctor who needs to come out after an operation and report to the family about what is happening. Okay. They don't come out wringing their hands and sobbing and saying, "Oh, what a horrible thing this patient is going through and what horrible pain and suffering they're dealing with right now as they're dealing with this agonizing circumstance," whatever it is. No, they come out as a matter of fact and they address the family and they tell them the extent of the situation, the prognosis, maybe the person is alive, maybe not. Okay, but they're just straightforward, just present the facts as professional as they can, as calmly as they can. The family will appreciate this tremendously, family and friends of both sides. Okay, don't emphasize and stress things, just report it. Now, the bottom bullet on here is something that's good for us. It's called the witness immunity doctrine. This allows us to testify freely without the fear of lawsuits. from our testimony. It's not a get out of jail free card at all. There's a difference in criminal charges and civil. What this witness immunity doctrine allows us to do is testify and not worry that somebody's going to sue us for the things that we say. Okay. Now realize we're under oath to tell the truth. If we say something that's not true, we'll be guilty of perjury. We go to jail for that. But we don't have to worry that somebody's going to sue us, because of some testimony that we give. But if you're on the witness stand and you admit to committing a crime, well, the judge can sentence you to jail right there because you just on the witness stand while under oath admitted to committing a crime. So the judge can sentence you to jail immediately. So you don't have a get out of jail free card, but you do have immunity from a lawsuit. Okay. A lot of resources out there, more than there used to be, but you guys are already in a graduate degree program. I used to run a certificate forensics professional certification program here at Cal Poly, but I've stopped doing that. There's a lot of professional training out there from the various vendors. I've had training from Guidance Software, the Encase people, from Access Data, the FTK people, and from Black Bag Technologies, the Blacklight people on the Macs. So in summary, working in the legal system imposes a huge responsibility on expert witnesses. Jurors rely on forensics experts to help them understand the meaning of electronic evidence. Jurors are not required to have any technical knowledge. Experts must and may have to refute or validate other examiners' testimony. See, an attorney might hire you to read somebody else's report and see if you can find any fault in it. Witnesses need to be prepared to withstand scrutiny from judges, jurors, and attorneys. That's one of the reasons this field pays so much. You think about what's at stake every time you testify. You could be out of a career because of a mistake. If you lie when you're up there on the witness stand, you got a lot at stake every time you testify. Witnesses have an ethical responsibility that cannot be compromised. If you think that if you bend the truth a little bit to try to help the attorney that's hiring you, you're going to get more work from that attorney in the future, you're mistaken. Because that attorney is going to know what the truth is. And if that attorney knows that you bent a little bit to try to help them, they know it's just a matter of time until you get caught doing this. And then it's going to backfire. It's going to unravel. And they're going to be afraid to use you in the future. But if you hold your integrity, and even if they want you to say something that's not right, you hold your integrity and you testify on the accurate information, the honest information, then that attorney is going to have respect for you. They're going to know they can depend on you. They're going to know where you stand, and they're likely to use you in the future. To be effective, you must understand a little bit about the legal system. You're not the legal expert, the attorney is. Okay, but you need to understand a little bit about the legal environment. The specific courtroom communication skills, how to listen to the question, how to learn to answer for the record. Okay. How to prepare for legal testimony, and skills for enduring cross-examination. Now, let me say one more thing about how to prepare for legal testimony. I left this out. Most attorneys will remind you when you take a case not to give them preliminary reports. Now, that's a really bad thing. So as you're analyzing the data, you'll keep your logbook, but that's your logbook. That's not a report. Do not write a draft report. Okay, that's a big problem. Now, you write a final report. Now, what you say, you write a final report, and then as you're proofreading, you find mistakes in it. Fine. Tear that report up and correct your mistakes, and then print it. but only have a final report. Okay. Don't have a preliminary report because that would be subject to be discovered or presented in the courtroom, and it could have some information in there that's not good. All right. If you're analyzing a case and you find some information that's either outside the scope of the work that you're working on or something that you think is critical information that the attorney needs to know about, do not write that down. Okay. You write it in your journal, in your logbook, but do not write it in a report. Do not write it in an email message. What you would do is contact the attorney you're working for and you tell them, we need to talk. They'll understand what that's about. They'll set up a meeting, either at their office or your lab or wherever. And then you can explain to them, or you can show them on the screen or whatever else, what you found, what the nature of this is that you need to talk about. If it's expanding the scope of the work, they'll either authorize it or tell them they're not interested in going further with that part. Or they'll tell you this is something important or something not to include in the report. That's fine, either way. But don't do not create a preliminary report and don't write stuff down like that. They'll caution you about that. Okay. All right. Let me ask now, I'm opening things up for questions or comments or concerns. Any questions about any of the stuff that I presented tonight? Any questions at all?
When we do lab 4, will we be assessed on our lab 3 findings?
Okay, great question. So your lab 3 report, you get graded on lab 3 based off the evidence you find and the quality of the written report that you produce for lab 3. Lab 3 is a team report, and I'm looking for your technical thoroughness here. I'm looking to see what evidence did you find and how well did you present that evidence in your report. So you'll get a lab 3 grade based off your technical competence with writing the report. All right. Now, after I've graded lab 3, I'll take your report again. I'll read it carefully, looking for errors, looking for any mistakes that you made. I'll make notes of those things. I won't tell you, but I'll use your lab 3 report as the basis for my questions to you on lab 4. Lab 4 is an individual lab, not team lab. I'll call each one of you to the witness stand individually. And I'll use your report against you. Okay. What will often happen, I'll ask you, do you have an occasion to conduct a forensic examination for the Price Software Company? Yeah. Did you complete your analysis in that matter? Yes. As a result of that analysis, did you produce a report for the court? Yes. Is this a copy of the report you produced for the court? Yes. It's your signature in here attesting to the accuracy of the information contained therein. Yes. In your report, you stated this. Okay. Yes. What procedure did you use? Oh, we did this. Is this the correct way of doing that? Yes. Would you always do it this way? Yeah. Would you ever do it this way? Oh, no. We always do it. Always do it that way. Yes. I'd like to direct your attention to page 17 of your report and ask you to read the paragraph that's highlighted in yellow. And you flip over to that page and you see that and you realize you just contradicted yourself. That's the way it often works with lab 4. Okay. So I grade lab 3 for its technical part, and I grade lab 4 based off the way you address your questions. Now, let me talk about how lab 4 works there. If I shoot you down in lab 4, that does not get you a bad grade at all. Okay. The thing with lab 4 is for you to maintain your professionalism and answer the questions honestly and accurately. My intention is to shoot down everybody in the class. That's my intention. Shoot down everybody in the class. To get you to contradict yourself or make some mistake or point out something that you're saying is not accurate. Okay, but you can do that and still make a great grade, right? Where you go wrong is if you start shouting at me, arguing with me, hit me. That's going to be kind of hard with a virtual lab, but something like that, hit me, kick me, that kind of stuff, that would be bad. Shouting at me, failing to answer the question, avoiding the answer, those kind of things will hurt your score. But maintaining your professionalism, answering the questions accurately and honestly, even if I shoot you down, you get a good score in the lab. Okay. Did that address your question?
Yes, sir, and more.
All right. Any other questions about any of this stuff? Any other questions? Most people find Lab 4 to be fun. They find it a little bit intense, but it's supposed to be, because when you provide expert testimony in court, it is intense. One of the things I had on the slide that I skipped over and meant to come back to it and didn't do it. It said that when you address the court, you should turn and answer to the jury and remain relaxed. Well, yes, we do turn and answer the questions to the jury, but being relaxed is something that's not likely to happen. And in fact, I don't think you should be too relaxed. I think you'll be a little bit nervous. That's normal. It's a normal human behavior. Look, you're on that witness stand. Every eye in the courtroom is looking at you. The judge is looking at you. The attorneys are looking, listening to everything you're saying. The jury members are looking at you. And the audience, they're all looking at you. And now they're asking you difficult questions. And the attorney's trying to mess you up. Of course, you're nervous. That's okay. It's a normal human behavior. In fact, showing that you're a little bit nervous shows that you're taking it seriously. That's good. And the jurors kind of expect you to be a little bit nervous. You're a computer nerd of all people. You're not a politician who's trying to give some charmed speech to the world and not meaning a thing that they say. Okay? You're an honest computer nerd. Okay? So it's okay to be nervous. All right? In fact, if you're too relaxed, if you were reared back in the chair and had your feet propped up on the desk, you wouldn't be taken seriously at all. Okay? So don't worry about being nervous. That's part of the job. Okay? Now it gets a little easier the more times you testify, but still, every time called to the witness stand, can't help it. And I'm used to being in front of a large number of students lecturing or giving presentations at conferences or whatever else. No problem getting in front of a lot of people and talking. But on a witness stand, I'm called up, there's always a little bit of nervousness there because there's so much at stake. Okay. Any other questions or comments about any of this? Well, I hope you'll find this enjoyable. Most people do. And I think it will help prepare you for the real world if you choose this profession. It's a whole lot better to make a mistake in the classroom than it is in the courtroom. And so working through this simulated court testimony will, I think, open up a lot of eyes. You're going to have a lot of fun with this. You'll get to have the pressure on you when you know everybody's watching you, but at the same time, you're going to get to watch everybody else. Everybody in the class is going to go through the same kind of thing. And you're going to see what happens. You're going to know when they mess up. You're going to realize, oh, I shouldn't have said that. But it'll be over before you know it. I'll ask you just a handful of questions and shoot you down, just over and over and over.
A quick question, Professor.
Yes.
So in this case, I know it's all virtual. Do we have to have our cameras on during the examination or?
Very good question. So let me tell you what I would like, and let me tell you what I can demand. By law, I cannot require you. I can't force you to turn your cameras on. Okay. I would like for you to have the cameras on. Okay. I think that's really good if we do, because then we can see the exchange. But I can't make you. That's the ruling is here with the university that would be an invasion of your privacy, because some of you are going to be, have your home setting behind you. You might not have your background blurred or some scenery like I've got, like a simulated courtroom behind me. And so it'd be intrusive to require you to turn that camera on. Okay. All right. So I can't require it, but I would like it if you can. It's not going to hurt your grade if you don't, but I would like it. Everybody in the class would like it if you can. If you can't, you can't. Okay. Okay. Any other questions or comments? All right, let me just take another quick look at Canvas here. Let me put this away. And remember, you have two parts to your lecture, your daily quiz today. There's a part 1 and a part 2. And that's it. Make sure you submit your lab 3 reports. And then next week, we're going to, oh, I know there is one more thing I need to show tonight. I forgot this. We're not done. I have some simulated court testimony that I want to show. It's a video recording of I'm gonna put a link out there on Canvas. I want you to watch this. So I'm not gonna make you deal with my lecture on this. I've already done this numerous times, and so I've recorded it. I'm gonna give you a link to a recording that I've done where I show video clips of court testimony. And this will help you prepare tremendously. I think you'll have some fun with it. What I've done is I've taken a comedy movie that has a lot of courtroom scene in it, and the courtroom is pretty accurate. But it shows opening statements. It shows eyewitness testimony. Opening statements, eyewitness testimony, both direct examination and cross-examination. It shows expert witness testimony, experts for the prosecution, and experts for the defense. It's going to show both direct testimony and cross-examination. It's going to show a voir dire, an expert witness getting voir dired. It's going to show all of that and all the way up to the closing arguments. Okay. It's a funny movie. It's a comedy. Has anybody in the class ever seen the movie My Cousin Vinny?
– Parts of it, sir.
What did you think
Excellent
about it?
film, 10 out of 10.
Excellent, 10 out of 10. Well, that's
Very good film.
Great. All right. Well, this time we're going to focus on the courtroom in particular. And I've already got the lecture recorded. I'll give you a link to it on Canvas. In fact, we'll do a screen share here. Should see Canvas here. I think this is it right here. The link to the video of court testimony. It's already turned on for you to watch. Let's just see if that is it, and then you can watch it on your own. I'll click on this, open this. What a handsome man. All right. Now let me scroll forward and make sure that's what it is. Let me scroll over here. Yeah, this is it. So let me stop that and exit this. Stop the screen share. So yeah, on Canvas, you have that link. Watch that link. It'll help you prepare for your court testimony lab next week. All right. Any questions? Let me make sure it is next week. Let me just verify that. If I come over here, back up one here. And yes, it is November 26th. Happened to be my grandfather's birthday. Yeah, the lab 4 will be next week. All right. Any other questions before we call it an evening?
Professor, just quick clarification. Just one person from our group submits lab 3, right?
Yes, one copy of lab 3 for your team. But when you do your lab 4, that's individual. Everyone on that team is on the hook for everything in that report. When I ask a question, you can't say, well, I don't know. Somebody else in our report wrote that part. That's not an acceptable answer. Your name's on the report. So you're on the hook for everything in that report. But you're right, one person per team submits the Lab 3 report. I'll grade it on its technical merits for Lab 3, and then I use it against you individually for Lab 4.
Got it. Thank you.
You're welcome. Any other questions?
Professor, for lab 3, we address the cover letter to you. Is that okay? Or should we
That's
direct
fine.
it?
You can address it to me, or you can address it to Stacy Price. Either of those are acceptable.
Not perfect. Is it also right if we resubmit our paper? I just want to change some verbiage. We
If-
submitted
if-
it earlier today.
Yeah, if a team submits more than one version, I always take the latest. I feel like your latest, your best and final. Okay. And I ignore the others. So the latest copy is the one that I'll count.
Okay, thank you.
You're welcome. Any other questions? All right. Well, please watch that video of the analysis of My Cousin Vinny. I think you'll find it enjoyable. And you probably will see things that you didn't pick up when you watched the movie before. It's like anything else. You have your favorite movie, you watch it multiple times. Subsequent viewing, you'll pick up some subtle details you didn't notice in a prior viewing. You'll find that here, I think. So, and now that you know the procedures of a trial with the opening statements and the witnesses for the prosecution, followed by the witnesses for the defense, you understand about direct examination and cross-examination. I think you'll find this to be not only entertaining, but enlightening. Right? Okay, well, enjoy it, and I'll see you next Wednesday.
Thank you, Professor. I hope you feel better.
Thank you. I hope so too. Today's not a good day. Okay. So long, everyone.